And indications have emerged that about 13 presiding officers deployed by the Independent National Electoral Commission, INEC, during the presidential election have admitted under oath that they transmitted results electronically. It was gathered that the presiding officers who are in Borno and Yobe states have agreed to testify before the Presidential Election Petition Tribunal that they transmitted results of the February 23 presidential election to the server of the Commission. The contention whether or not results were forwarded to a central database of the Commission has been among the top grounds for contesting the presidential election results by the presidential candidate of the People's Democratic Party, Alhaji Atiku Abubakar. Atiku was the main challenger to President Muhammadu Buhari at the presidential election on February the 27th. INEC declared Buhari winner of the elections and issued him a certificate of return for a second four-year term starting May 29. Well, the All Progressives Congress had tackled Mr. Atiku over his claim that results from INEC servers showed that he won the election. INEC also dismissed Mr. Atiku's claim, saying the results he paraded were fabricated. But the People's Democratic Party presidential candidate said he's willing to engage experts to verify his claim. Well, what do we make of all of these issues coming in following that Presidential Election Petition Tribunal? Let's find out from INEC's position with the back and forth over this from further explanation. Joining us from our Abuja studio is the Director for Voter Education and Publicity, Mr. Luwole Osaze-Ozie. Thank you so much for joining us at this time. We know that sometime in 2018, INEC came out and said that it had adopted card readers and ruled out electronic results. So can you explain what it is we're hearing with, ad hoc staff, POs saying that this wasn't adhered to, talking about the guideline now?
Well, thank you, Ms. for having me and compliments. Well, let us be very careful because we're treading on a very thin ice here. Treading on thin ice in the sense that these matters are before the Court of Appeal. The Court of Appeal sitting as the Presidential Election Petition Tribunal. And we can discuss about the pleadings, what each party has put forth before the court, but we cannot discuss the merits of that of the respective cases because it is sub judice. It is the subject of litigation, and we should not say or do anything that will preempt the ruling, judgment, or determination of the case before that court. But basically, yes, we did say that rule it out in the sense that, one, the law, the Electoral Act 2010 is amended, which was used for the conduct of the 2019 presidential and other elections, was not successfully amended before the conduct of elections. So there's a procedure recognized by the law for the transmission, collation, and declaration of results. And we insist, our case before the tribunal is that we followed these procedures. We had hoped that there would have been some electoral amendments or amendments to the Constitution that would have allowed us to use alternate means. And those were the proposals before the Electoral Act Amendment Bill. But regrettably, unfortunately, that bill was not signed by the President, so it did not become law. So we used the method and methodology outlined in the Electoral Act, in the extant law for the conduct of the elections.
What furthermore can you tell us? Notably, you've said that these, discussions are definitely sub judice, but interestingly, social media has been agog with a lot of people reacting to this and, trying to figure out how that will play out. But I want to ask about what INEC is doing now, especially for the Electoral Act, and that's the amendment bill. If indeed that you hope that Mr. President will sign it, especially as you, I'm sure, are already gearing up for 2023.
Yes, first of all, we don't rely so much on social media in the determination of cases. The justices who are going to determine that case don't look at social media. They'll determine the case upon the pleadings of the parties, the petition, the response, and the replies. They will also determine the case on the evidence led and produced before the court by the respective political parties. I've read a lot of things on social media. Many of those things are incorrect. They're not even reflective of the pleadings of the parties. They're not really reflective of the case before the court. And law is forensic, law is technical, especially electoral law. But I've heard commentators from people who are not even lawyers and some lawyers who are not very experienced in electoral matters comment on the pleadings and comment on things. Many of those comments are misleading. Many of those comments are not even issues to be tried. And even some of the cases or defense put forward have been misinterpreted by lay people and even some uninformed lawyers. It's incredibly amount of information we have out there on social media, most of which is quite misleading. As I said, we'll wait for the tribunal to determine the case. But as what INEC is doing, just like most Nigerians, we noticed that I think in the last week or so or thereabouts, we understand that the Senate passed the Electoral Amendment Bill. We have not been opportune to see that bill. We don't know whether it's exactly the bill that was presented before the president for his accent or whether certain things have been corrected in them. I really don't know, so it's difficult for us to comment on a bill we haven't seen. But going forward, first of all, people have to note that apart from the Senate, the House of Representatives also has to pass that bill. And if it's different from that passed by the Senate, then both bills have to be reconciled. So we're still some way away before that the bill is again presented to the president for his assent. And if he agrees to assent, he probably has to do that before May 29. So we'll still have some way to go. But we hope that the Electoral Act will be amended, the laws will be amended. Lots of issues have been thrown up by the 2019 elections. And apart from those ones we had envisaged, apart from those ones that have been taken care of, we think new challenges have been thrown up. And it's something we, as Nigerians, we as citizens have to look more carefully about. The Commission itself will be studying those things. And quite honestly, a few things might be thrown up in the tribunals. And these things have to be looked at critically and with a way to paving the way for comprehensive and holistic amendments to the legal framework governing our electoral process. But it's something we're studying. We've asked for a copy of the bill passed by the Senate. I'm not aware that the Commission has gotten it yet. But when we do, we'll study it and see what the kind of inputs. Fortunately, in the past, there have been public hearings and memos have been submitted by the Commission. We will certainly do that again if it's brought to our attention.
Let's talk about the timeline you brought out for the elections this year in Kogi and Bayelsa states, your preparations towards that, especially permanent voter card collection in those two states.
Yes, we brought out the framework, we brought out the dates and comprehensive timetable and schedule that the political parties and stakeholders have to follow. The back-end things we have to do, including issues of registration, issues of collection of permanent voters' cards. The Commission will make its position known on some of these things as we go closer. November 2nd is a date that we intend to conduct both elections. But definitely more details will be released to the public as the days go by, and we hope that we can capture many more cards are left to be collected in those two, even for people who have registered since 2010. Many of those cards are yet to be collected. We hope the majority of the cards will be collected before the end date for collection of cards to be used for those two elections.
All right. One other thing also is, I mean, with the rate of inconclusive elections that we had in some states, the process really started before the election date. And this is what, citizens of these two states do not want to happen in terms of your preparations.
Well, the way we keep talking about inconclusive elections as if it's a bad thing, it's a bit worrisome. I think when we critically examine things, and coincidentally, both states, last time around, both states were inconclusive. Now we have to examine the reasons for the inconclusive nature of the elections. The main thing being violence or the interjections or the attempt to subvert the process by the political class in both states. But don't forget also the intervening death of the candidate for the APC in the last elections threw up some interesting legal and constitutional matters. And the issue of inconclusive elections was determined by the Supreme Court in Falek's case against INEC from that last election. And of course, the Supreme Court gave its imprimatur. It's validated INEC's position that yes, INEC was correct to declare that election involving Boubacar and the president as inconclusive, and the PDP candidate as inconclusive. So that was validated by the Supreme Court. We certainly hope that if any candidate meets the criteria for elections In the first round, we'll declare election concluded and declare winner in both states. But if violence or if other intervening factors make it impossible to conclude on the first round, then we will, if the law remains the same as at the time of November 2nd when the elections were, we will not fail to comply with the law and declare the elections inconclusive.
Right.
If that's what the law says, we're obliged to do so. We have no choice.
Well, I'd like to thank you so much, Mr. Oluwole Osazuzi, for joining us on the program.